In the matter of MS ASP traders versus the state of Uttar Pradesh, Supreme Court allowed the appeal and set aside order passed by the High Court. The appellant was a registered dealer in red arecanut operating from Channagiri, Devanagari, Karnataka. On 14th of January 2022, they consigned 17,850 kg of dry arecanut valued at rupees 51,72,930 packed into 255 bags to one MS Diamond Trading Company, Delhi. During transit, goods were transshipped and loaded onto another vehicle bearing for onward journey to Delhi. However, only 248 bags were loaded onto new vehicle with 7 bags missing from original consignment. On 17 January 2022, said vehicle was detained by mobile squad at Lalitpur Bypass Road, Jhansi. The driver's statement was recorded. Following physical inspection, report was generated alleging certain deficiencies. Subsequently, a notice dated 21st of January 2022 under section 129(3) of Central Goods and Services Tax Act 2017 was issued in Form GST MOV 07, highlighting the discrepancy of 7 missing bags and resulting shortfall in quantity from 18,220 kg to 17,670 kg. It was further alleged that consignee MS Diamond Trading Company was prima facie non-existent and that address of consignor was incorrect as per departmental records. Issue that arose for consideration in this appeal was whether, upon payment of tax and penalty by appellant within stipulated time in notice under section 129(3), proper officer is still mandatorily required to pass final order under section 129(3 or whether the deeming fiction under section 129(5) dispenses with such requirement. The IGST Act 2017, CGST Act 2017, and SGST UTGST Act 2017 are interrelated parts of goods and service tax regime in India. All three enactments originate from same constitutional amendment, 101st Amendment Act 2016, aimed at establishing harmonized indirect tax structure under philosophy of one nation, one tax. While tax base and compliance framework are integrated, acts are separable to reflect federal distribution of taxing powers. Section 129 of CGST Act 2017 outlines mechanisms for detention, seizure, and release of goods and conveyance in transit. Subsection 1 authorizes detention and prescribes conditions for release. Subsection 3 requires proper officer to issue notice specifying tax and penalty payable and thereafter pass an order. Subsection 4 mandates that no tax or penalty shall be determined without providing opportunity of hearing. Subsection 5 provides that upon payment of amounts under subsection 1, all proceedings in respect of notice shall be deemed to be concluded. Rule 142 of CGST Rules 2017 reinforces and operationalizes provisions of Section 129 of CGST Act 2017, particularly with regard to procedural aspects of issuance of notices, orders, and payment of tax and penalty in cases involving detention, seizure, and release of goods and conveyances in transit. Subrule 3 states that on payment of tax and penalty under Section 129(1), intimation shall be given in Form DRC 03 and proper officer shall issue an order in Form DRC 05 concluding the proceedings. Subrule 5 mandates uploading summary of final order in Form GST DRC 07. This circular, which is binding on department under Section 168 of CGST Act, provides detailed instructions to ensure uniformity in implementation of procedures for interception, detention, seizure, and confiscation of goods in transit. It mandates that upon payment of tax and penalty under Section 129(1), proper officer must issue release order in Form GST MOV 05. Additionally, officer is required to pass formal order in demand in Form GST MOV 09 uploaded on common portal. Summary of this order must be uploaded in Form GST DRC 07 so that demand is recorded in taxpayer's electronic liability register. Appellant has categorically pleaded that due to business exigencies, they paid the tax and penalty and secured release of goods and vehicle detained. This payment, however, cannot be construed as admission of liability for alleged contraventions of the Act. It was further stated that payment was made under protest and appellant had intended to contest the matter. Therefore, proper officer was bound to pass a speaking order under Section 129(3) to enable appellant to exercise their statutory right of appeal. In contrast, respondent authorities asserted that payment was made voluntarily by appellant prior to passing of order under Section 129(3 and appellant's authorized representative had withdrawn objections earlier filed. Accordingly, they stated that in terms of Section 129(5), all proceedings stood concluded and no further order was required to be passed. Discharge order merely records that the detained goods and vehicle were released upon payment of the proposed tax and penalty. It makes no mention of any withdrawal of objections or of the conclusion of proceedings initiated under Section 129(3) of CGST Act 2017. It is a well settled principle that every show cause notice must culminate in a final and a reasoned order. While Section 129(5) of CGST Act 2017 provides that proceedings shall be deemed to be concluded upon payment of tax and penalty, this deeming fiction cannot be interpreted to imply that assessee had agreed to waive or abandon the right to challenge the levy, a right that is protected by the very enactment itself. The term conclusion, as used in Section 129(5), merely signifies that no further proceeding for prosecution will be initiated. It does not absolve the responsibility of proper officer to pass an order concluding proceedings. Therefore, proper officer is duty bound to pass a formal order in Form GST MOB 09 and upload summary thereof in Form GST DRT 07 as mandated under Rule 142.5 and Circular dated 13 April 2018 to enable taxpayer to avail the appeal remedy as per law. In present case, payment was made under protest and objections had been filed by the appellant. Once objections are filed, adjudication is not optional. It becomes imperative to pass a speaking order to justify demand of tax and penalty to safeguard the right of appeal under section 107 of the CGST Act 2017. Language of section 129(3) is categorical in stating that officers shall issue a notice and thereafter pass an order. Use of the words and thereafter reinforces mandatory nature of passing a reasoned order, regardless of payment, particularly where protest or dispute is raised. Although respondents claim that the objections were orally withdrawn and that payment was made voluntarily by the appellant, no written material has been placed on record to substantiate the same. As between a written reply and an oral submission, contrary to such written submission or reply, written reply would prevail, and authorities are duty bound to consider that reply and pass speaking orders addressing each and every contention. Significantly, GST payment portal permits payments only through Form GST DRC 03, which is automatically classified as a voluntary payment and does not provide any mechanism for assessee to indicate that payment is being made under protest. In absence of such an option, payments made under commercial compulsion or business necessity, such as for securing release of detained goods, may be erroneously construed as voluntary, resulting in undue prejudice. Under such circumstances, written objections become significant to understand intention of assessee or owner or transporter. Upon such payment, system auto-generates Form GST DRC 05, thereby concluding proceedings without formal adjudication. Such procedural limitations cannot be allowed to defeat rights of taxpayer, particularly where detention of goods is ultimately found to be unlawful. Court said that we are therefore of opinion that payment made by the appellant in the present case cannot be treated as voluntary. And the absence of mechanism to record protest should not operate to detriment of the assessee, especially when objections were already on record and payment was clearly necessitated by business exigencies. The payment by assessee will not absolve responsibility of proper officer to pass order justifying demand of tax and penalty. Assessee, even by election, cannot be treated to have waived his right against illegality committed by proper officer or acquiesces to the demand as by the constitutional mandate under Article 265 of the Constitution. No tax can be levied or collected except with the authority of law. There is not only a bar against levy but also against collection. Therefore, action of the proper officer must always be justifiable and fall within four corners of law. A waiver, as settled, is an abandonment of right by express terms or by implication. It is an act by which a party elects to abandon his right to pursue a particular remedy with full knowledge of its existence, making the other party to alter his position or legal status. Acquiescence, on the other hand, will imply the conduct of the party who refrains from taking any action for a long period of time despite knowledge of violation of his right, thereby precluding his future right to agitate the issue, as it would be hit by laches. The payment by itself cannot be treated as waiver of abandonment, especially when the appellant has clearly objected to the demand and when there is a statutory mandate to pass an order and corresponding right to the appeal. Principles of natural justice mandate that when a taxpayer submits a response to the show cause notice, the adjudicating authority is required to consider such response and render a reasoned speaking order. This is not a mere procedural formality, but a substantive safeguard ensuring fairness in the quasi judicial proceedings. An appeal can lie only against an order, and in the absence of a reasoned order passed under Section 129(3) of the Act, such taxpayer is effectively deprived of the statutory remedy of appeal. Such a deprivation undermines the foundation principles of fairness, due process, and access to justice, rendering the right of appeal illusory or nugatory. It is now settled law that failure to issue a speaking order in response to show cause notice creates a legal vacuum. Any consequential action, including imposition of tax or penalty, would then be unsupported by authority of law, thereby potentially violating Article 265 of Constitution of India, which prohibits levy or collection of tax except by authority of law. Useful guidance may be drawn from the decision in MS Kranti Associates Limited and another versus Masood Ahmad Khan and others, wherein the court emphasized that fairness, transparency, and accountability are inseparable from duty to provide reasons. The court held that failure to furnish reasons violates principles of natural justice and renders right of appeal or judicial review illusory. Payment was stated to have been made under protest due to business exigencies, and appellant sought to challenge the levy. The proper officer was under a clear statutory obligation to pass a final order under Section 129(3) in Form GST MOB 09 and DRC 07. The refusal by the High Court to direct the passing of such an order has the effect of frustrating the appellant's statutory right to appeal and is contrary to well established legal principles governing tax adjudication and procedural fairness, said the court.